One of the most central documents to any real estate transaction is the property deed. It's a legal document that transfers property ownership, and they will always be in writing. The grantor is the party releasing the title. Normally, this is the seller of the property, and the grantee is the one receiving it. So this would be the buyer or recipient. These two parties must always be identified on the deed. Certain local laws may require both parties' residences to be listed as well. The deed must be signed by the grantor in the presence of a witness, who must also sign. The deed is then delivered to the grantee. Once the grantee accepts the deed, it's finalized. There's sometimes confusion by buyers and sellers about the difference between a title and a deed. They're not terms that can be used interchangeably and are actually quite different. The main difference is that the title shows the rights to which a person is entitled, and the deed is the legal instrument that confers those rights. In other words, the title shows the ownership, and the deed is the legal document that has the power to assign or transfer the ownership. There are many different types of deeds, but the ones we'll discuss here are grant deeds, warranty deeds, and quitclaim deeds. These three are the ones most often used to transfer the property from one owner to another. A grant deed is a deed that transfers the title of a property to another person. This kind of deed must legally describe the boundaries and often the parcel numbers. A grant deed has to be signed by the parties transferring the property and be acknowledged before a notary. One of the important things to note is that a grant deed shows that the title has not already been transferred to someone else. A grant deed is a deed of conveyance that is specific to real estate. A deed of conveyance is simply a deed that certifies the transfer of ownership rights of a piece of property from one person to another. A warranty deed is another common instrument for the transfer of real estate title. The main feature of a warranty deed is that the grantor guarantees the title has no defects or clouds on it. This kind of deed offers the most protection to the person receiving the title, since the seller can be held liable if there are problems that arise on the title. There are two types of warranty deeds: special warranty deeds and general warranty deeds. A special warranty deed transfers the title to the grantee while allowing the grantee to hold the grantor liable for any clouds on the title that relate to the period of time when the grantor held the title. On the other hand, a general warranty deed transfers the entirety of the grantor's interest in the property, but also makes it so the grantee can hold the grantor responsible for any problems that occur with the title, regardless of whether the title defects occurred during the time the grantor held the title or not. While officially transferring the property title to another person, a quitclaim deed simply releases the interest the grantor had in the property. A quitclaim deed does not offer any guarantee or protection for the new holder from clouds on the title. This kind of deed doesn't even ensure that the grantor actually owned the property. However, it does prevent the grantor from making any future claims to that property. Often, this kind of deed is used to transfer titles between family members. Given the risk connected with a quitclaim deed, these kinds of deeds are rarely used to transfer titles from sellers to buyers. They're also sometimes used to transfer the title of the property when property is bought at a public auction. While deeds are one of the primary instruments used for transferring the title of real property, there are a couple of other ways this can be accomplished. Let's talk briefly about a few other deed-related concepts. A land sale contract is a contractual agreement in which a buyer purchases property from a seller on an installment basis. After the contract is established, the buyer typically takes possession of the property and makes regular installment payments to the seller until the total balance of the sale price is paid in full. Other common names for land contracts are real estate contracts, installment sales contracts, or contracts for deed. Probate is a legal process by which a person's will is proven to be valid. In addition, probate is also the process by which an estate is distributed to descendants. Properties and their titles are transferred to new owners after the previous owner dies. Probate validates or invalidates a will, which either forwards the title transfer process or stops it while the will is being examined. Finally, adverse possession is a process through which the title and ownership of a property can be seized by someone without any formal transfer of title. The conditions required for a transfer of title by adverse possession are very similar to the process that establishes an easement by prescription. There's a statutory period defined by local laws that details how long the property has to be occupied for the title to be transferred via adverse possession. Understanding the process of transferring real property titles is an essential aspect of being a real estate professional. Anytime property is sold, willed, or simply handed over to another person, the title and the associated bundle of rights is transferred to the new owner and a new deed is drafted.